Hello, my name is Mark DiCarlo. Tonight my guest is D.A., District Attorney for the 79th Judicial District in Jim Wells County and Brooks also. Is that right?
That's correct, yes.
Mr. Carlos Omar Garcia.
Yes, sir.
Unusual middle name.
Well, I think my mom got it because when I was being born, she had a thing for Omar Sharif, so that's where the Omar came from.
I was going to say, I'm surprised you use it so prominently because people always like to say Barack Hussein Obama like he's some sort of a
No, I think
terrorist or something.
Carlos and Garcia are kind of common, so pretty much to identify which Carlos Garcia you're talking about, that's why I use the whole middle name.
Well, how long you been DA over there? And that's Jim Wells County, and I think Brooks County you said also, right?
Yes, been district attorney since I took office in 2013. So this is the latter part of my first term.
Well, and you unfortunately already garnished an opponent, right?
That is correct, yes.
Well, and you know, obviously, I think most people know that the district attorney's office is basically Judge Westergren years ago said you're a politician. In other words, you run on a political party, correct?
Yes, you have to run on a political party, but then you also have the actual work of the district attorney, which is basically, at least in our jurisdiction is a traditional DA's office where we only handle the felony cases. Unlike, I know in Nueces, it's a criminal district attorney's office where they handle from misdemeanors all the way up.
I don't think it's done very much. I don't think in most counties they handle county and misdemeanors and felonies, right?
Right. Most of the I think the bigger jurisdictions like Nueces or Cameron County or Bexar County, Harrison, most of those bigger jurisdictions have them where they're criminal district attorneys' offices where they handle it from all levels of the criminal cases. But on the smaller jurisdictions, it generally is split up between the county attorney and district attorney's office.
Well, the big publicity that's going on right now is something called the Michael Morton Act. And right now it's a hot topic in Nueces County, Texas. A lot of the young criminal defense attorneys are asserting that they did not get all the evidence in a case. So, my understanding is the Michael Morton Act was a law passed by the state of Texas, by the legislative body, and they stated that obviously that there were too many people. I believe it's based upon actually a case, Michael Morton, correct?
Yes.
And Michael Morton was wrongly convicted. And what do you know about the Michael Morton case?
Well, I know he was an individual that was convicted for the murder of his wife, and there was some information that the prosecutor and the investigators had that they didn't turn over to the defense. I think they kind of tied it into a different case, or whatever the way it was. It didn't get turned over, and this individual ended up serving 23, 24, several years behind the bar for his conviction. He was accused, he basically lost out on those years of his life. He also lost out on basically being able to raise his son. And his son, I believe, was also a witness that had told somebody that, it wasn't his father, that it was a monster who had done it and had given a description, and that also, I believe, was never conveyed, or at least my understanding of what happened, it wasn't conveyed to the other side. And so I think because of that, I think the Michael Morton Act was something that needed to happen. But one of the things is when it got passed, when you get these kind of laws that are passed more as a reaction to something that went wrong, sometimes you don't flesh out all of the things that maybe needed to be fleshed out. And right now, I think that's what we're dealing with. When you mentioned about things that are going on in Nueces County, these are things that back in 2013, when that law came into play, the Michael Morton Act was passed, and everybody started studying it and seeing, well, what are we going to have to do in our prosecutor offices to comply with it?
In other words, all the evidence is supposed to be turned over to the criminal defense attorney.
Yes.
All of the evidence.
Yes.
And I should have probably actually brought the statute, but I did want to hit one point, and I don't really like taking the side of the district attorneys who prosecute these cases, but there's a lot of evidence. And what is evidence could be very confusing. I know one of the attorneys in Nueces County said, well, you didn't, I think something like, you didn't give me, or you didn't tell me that there was a disc that was recorded that was inadvertently erased. And they said, well, that's evidence. It's supposed to be all of the evidence. So I can see there's probably a lot of judgment calls, about the evidence, especially in a major criminal case, about the evidence, what is evidence, etc. How are you handling all this?
Well, the way we're handling it is everything that we're getting, we are actually scanning everything in. We're bait stamping everything that gets scanned in. So that
bait stamping is a numbering system used by lawyers. It'll go, obviously, then you're numbering them page by page. This is page 1, page 2, page 2, thousands of pages.
Yes.
I'm sorry.
Yeah, and through that bait stamp so that we can keep track of what we have, and then when we turn it over to the defense, they would have those same numbers. So if there's something that's missing, we could hopefully be able to document we didn't turn it over because we never had it. But the scary thing is, and when I say scary, I'm talking about from the side of the prosecution. The way they look at it is anything that the state has, we're basically implied with that knowledge that we are aware of it. And so a lot of times we're trying to document, well, what if the police department had that information, but they, for whatever reason, didn't think it was part of that case. They turned everything else in except for that one item. So we're not even aware that we don't have it.
I think in Nueces County, Texas, I think that the police sign off on, I can't remember if the police are signing off on a statement that they gave all the evidence.
And we do the same thing. We get the police officers, so what they'll do is they'll turn in a case to our office. One of our investigators will then input the case into our system and create an evidence log. This is everything that was turned in. We'll then send that back so that officer can review and make sure, yes, that was everything I gave you, and acknowledge that it's complete, that there's nothing that's missing from that case. But could it inadvertently be it could, because you could have some officer that maybe was just working traffic, wasn't really part of that case, that saw somebody in a red shirt run by and he never told anybody. And later on it becomes important because the person who got arrested was a person in a white shirt, and he's trying to say, it wasn't me, it was somebody else. And somebody saw a second person run out there, but because they weren't part of the actual investigation, they were out there working traffic, they never wrote up a report, they never put it in a state. So those are the things that we worry about, and we want to know, well, you're the lead investigator. Is everybody listed in there who was out there, not just the ones that were directly connected with the actual investigation?
And but in your county, because I tried at least maybe 2 major cases over there some years ago, you did always have an open file policy, and I must say that I can't remember getting burned in that murder and sexual assault case that I tried over there by the prior district attorney, Joe Frank Garza, right?
Yes.
I don't recall getting burned when evidence was withheld. But there is another issue regarding when the attorney who is defending the accused criminal, will say, or the accused, when you get it. In other words, if you get it less than 10 days before trial, it's obvious that your trial strategy might have to change if you obtain this evidence. So is there anything in the Michael Morton Act which makes it so that the prosecutor has to turn over all of the evidence to the defense, the forensics, the videotapes, the police statements, etc.? Is there anything in the Michael Morton Act that says how many days we're entitled to get it before trial?
Not in specifics like days, but it does basically mandate or that to comply with it, the state has to give it in basically a reasonably timely fashion, so it's got to be given in a time where, in other words, you can't use it, or you shouldn't be, the state shouldn't be using that as a trial tactic or strategy
Right.
to say, well, you know what,
To win.
this is something that's important to them. I'm going to give it to them, but I'm going to give it to them right. It shouldn't be that way. I mean, it needs to be turned over as soon as it's available to us. It ought to be made available to the defense. At least that's my point of view on it, because then you are going to get those situations where it's like, okay, well, you complied, but did you really comply? I mean, it wasn't timely. You know, the timeliness wasn't there. Now, as a defense attorney, you're bringing it up to the court and basically saying, well, look, judge, I would have done something different, or I would have prepared differently, or I would have tried to look into this had I had it. Now we're about to pick a jury, or I'm about to go into the next witness, and
You just got this, so I need a continuance, etc. And most of the real important issues about the Michael Morton Act regarding all the evidence has to be turned to the other side. I would assume most of them have to do with the murder trials and the bigger trials, because there's a lot more evidence, right?
A lot more evidence, but then I think a lot of times you're also looking at the seriousness of the offense,
Right.
too. You know, somebody...
First time DWI, you're going to get probation anyway, right?
Right.
So what's a big deal? Well,
yeah,
you know,
they're probably
it's
not
like
gonna
losing
complain.
25 years, right?
Exactly. They're probably not going to complain about it as much, because they'll probably go through their probationary period and get off of it. Whereas somebody who, let's say it's a murder case and they get 40 years, they've got nothing but time to think about what went wrong in their case. And
I'm sorry.
no, well, they've got time to think about what went wrong in their case. And later on, as they're looking into it, say, well, wait a minute, you know, this never came out. My lawyer never talked to me about this. What? And then the lawyer might say, well, you know what? I didn't talk to you about it because I never got it. You never got it.
Well, you know, I'm going to say something that I think I was the first attorney that I knew of to do. You know, when I start practicing 30 years ago, I get all the evidence, right? Because we've had always open file policy in the last 30 years at least in Nueces County under Grant Jones, Carlos Valdez, Mark Skirka, at least in theory, you know. Mm-hmm. Though there's some, you know, again, obviously some violations on the bigger cases may have occurred. But I gave all the evidence to the criminal defendant. I said, here's all the evidence. My idea in doing that, though, was so I thought the criminal defendant would be able to help me and to pose some questions and to point out a trial strategy or something. But I could tell you, just talking gossip and shop, in all the years I gave people that evidence, I think I've gotten one good question. I don't know if they don't want to read it, or the system is much more complicated than what I understand. You know, for them as laymen, but virtually no good questions have come out of 30 years of giving a criminal defendant all the evidence in the case. So, you know, that's interesting too. I don't think is a Michael Morton Act require the criminal defense attorney to give the evidence to the defendant too? I don't think so. I don't think that's discussed.
So. And there's actually some areas in the code where when they wrote it up, some information is actually protected, where as a defense attorney, you can't give it to them. You can go over it with them, but you can't give them, you know, a copy of it. So I would say, you know, there's a lot of things that I think right now are cutting towards the prosecution on violations or non-compliance of the Michael Morton Act. There's a few areas in there that, you know, potentially could cut towards a defense attorney if they're not careful. And let's say you have somebody in jail that has copies of information that, well, wait a minute, that's not allowed. Where did you get this copy? Well, my lawyer gave it to me.
And that's another issue.
Yes.
That's very complicated. I guess you know, including medical care. You know, did the Michael Morton Act mention anything about turning over medical records under HIPAA violations, and then
not specifically, but that has been a big discussion, because when the Michael Morton Act came in, it said, okay, this is the new rule, this is what you're going to have to follow, but then they didn't give any guidance on, okay, how are you going to implement it? How are you going to put it together? How are you going to keep track of it? What does this mean to those type of records? They didn't flesh any of that out, so it kind of left everybody to kind of figure it out on their own and see, well, what would be the best practices based on what we think they meant when they passed it.
You know, I'm going to say something that's probably controversial that I said on one of my Facebook page in criminal law, which is this. let's be honest. Whether it's the Hannah Overton case that was overturned, etc., they're blaming it all on the prosecutor. But what about the courts of appeals that traditionally rubber stamp, in my opinion, everything the DA's office does, everything that every egregious mistake a judge makes, and perjure testimony by the police? In other words, they're blaming all these miscarriages of justice on the DA's office for not turning over the evidence. But that court of appeals in Nueces County, and every court of appeals I've been before, pretty much, even probably the Fifth Circuit, what do they say? Oh, that's harmless error. Mm-hmm. Oh, no, that doesn't make any difference. The defense attorney didn't properly object, or all these hyper technicalities. But they're basically rubber stamping everything. And I'd be curious if I knew more about, if I had the time, and I knew more about that Michael Morton case, who was the criminal defendant, I guess, should that appeal in the fact circumstances, if he was really innocent, it's hard to believe there would have been that much evidence. And I'm wondering if the Court of Appeals wouldn't have looked at that case closely if it shouldn't have been overturned. So in other words, what I'm saying is I'm wondering if they're not making the district attorney's office scapegoats for the actual courts of appeals, which seem very pro-prosecution oriented to me. Do you have any thoughts on that, or do you disagree with that?
Well, when you say about rubber stamping, I've worked on a lot of appeals on the prosecution side of it. I worked on a couple on the defense side of it way back, when I was between 95 and 97, I did some criminal defense work, and I did do some appeals back then, and I can say there were some things in that case that I thought it should have been overturned, and it wasn't overturned. So I kind of agree with you on that side. On the ones that I worked on the prosecution side, I reviewed one that I didn't work up, but it was in the office when I took over, and the Court of Appeals ended up upholding the conviction.
Always.
I didn't see it that way. I don't know that if I was doing it, I don't know that I would have conceded to certain points, but it seemed to me I would have probably agreed to a new trial at least, because there were some issues in that case that just didn't, so I think it kind of depends on the panel you're going to get on that on the Court of Appeals, but the way the rules are set up and the different case law, it is set up to protect the whatever judgment came out of the court. And if you're dealing with on the criminal side, if it's going to be an appeal, well, then it's generally that there was a conviction. So it's already written up.
But that's based on prior cases from courts of appeals. Not based upon, I don't think, of the rules of evidence, etc. In other words, they have this body of case law, most of our courts of appeals saying, that's all right, again, that's harmless error. And okay, first you were supposed to object, then you were supposed to move for I can't remember. Then you were supposed to ask for an instruction, and then you were supposed to move for a motion for mistrial. Because all three of those weren't done by the criminal defense attorney in the heat of the trial, even though this was an important piece of evidence, we're going over, I think it's ridiculous. I think it's gotten to the point of the ridiculous, the hyper technicalities that the criminal defense attorney is supposed to do. And then the most ridiculous thing, it's similar what they've done to the prosecution as they've done for years on the defense. They started this maybe 10 years ago. The judge can't make any mistakes. The prosecution can't make any mistakes. The only, perjury doesn't make any difference. The only thing important is was your criminal defense attorney ineffective? That's the only way we're going to overturn a case is if the criminal defense attorney is ineffective. And I would argue that, of course, what they're doing is they're destroying your right to an attorney, because it makes you a natural enemy of your attorney almost from the beginning. Now with the Michael Morton Act, they're saying the only thing, again, the prosecution, the attorney is wrong. Not that the judge made the wrong decision, not that this was an unfair trial. and of course, I'm editorializing about that and the Michael Morton Act. So generally speaking, is your office is trying to comply with the Michael Morton Act.
Yeah, and basically the way we're trying to comply with it is, I can say that every case that we've gotten since the Michael Morton Act is probably more than double the amount of time we have to put in documenting everything, because that's the only way we can prove what we had and we gave to you, or we didn't give to you, or what we didn't have so we couldn't give to you. So whereas before we were taking everything law enforcement had, and yes, we had an open file policy. You come to the office and say, here's open file, we'll make you a copy of everything, you can look through it, here you go. And you'd look through it, but what if we never got it and it's not in there and it was something that was important? Well, I gave you everything I had, but I didn't give you everything they had, which was the law enforcement agency, because somebody over there didn't think it was important to the case. Right. It's like they took that away. The law enforcement can't make that decision anymore, but you know what? Neither can the state. I can't make that decision that this isn't important. If I want to withhold it, I need to tell you, I'm going to withhold it because I think you shouldn't get this, but I need to at least let you know I have it so that you can try to look at it.
I think the Michael Morton Act actually say all exculpatory evidence? Is that the wording?
No, they ended up. It deals with the Brady type material, the exculpatory, the mitigating, but when we were always dealing with Brady on those type of issues and the impeachment evidence, it was always something that was it material to the case? Is it material? Well, when they wrote it up in the Michael Morton Act, they took materiality out of it and just said, we've got to turn over all information. And that's a lot broader. And so it's like, well, okay, now it's not whether it's material or not. It's just, do we have it so that a court can decide, you know what, it does need to be turned over, and then can order, yes, turn it over, and we'll, But before, it was usually a prosecutor that was going to make that decision and say, well, you know what, this isn't really material, not to this case. Now it's like, well, don't do that, because if you're wrong, you're going to get tagged with a violation of it. And, I think, earlier before we started recording, we were kind of discussing some of these issues, and I was kind of telling you that this is the scary part because of some recent grievances that have been filed against a prosecutor out of Denton County, where they ended up suspending the prosecutor's license. But in there is what they ended up saying is, intent has nothing to do with whether you violated. You either did or you didn't. And they were saying you got to be careful, because let's say somebody else in the office knew this information. And let's just use another prosecutor. Prosecutor went in and they were handling the case, but you know what? They got sick, so they're going to be out of the office for the next 6 months. I end up taking it over, but I didn't know that prosecutor had talked to a witness, and that witness had told the prosecutor, I'm not really sure anymore if that was him. But I didn't know that. It's not written on any note. But during the trial, let's say you're on the other side, you're cross-examining, you say, hey, did you ever tell anybody that you didn't? Yes, I did. I told the DA's office. I'm like, told the DA's office, I didn't know about it, but I'm the one that's handling it right now. I'm the one that, and how are they going to handle that? I don't know, because that particular set of circumstances hasn't come up, or if it has come up, it's just not where we've been able to read about it yet.
I'm going to broaden it, and I'm going to say that's the element of fascism that I've seen that has occurred in American law since I've been practicing, wherein there doesn't have to be an intent.
Right.
In other words, you're strictly liable if you did it. Well, I think it's, I personally, I don't know. Is that it's kind of like zero tolerance.
Right.
You're not entitled to any. Well, you did it. Well, I didn't know. Well, that's not a defense. I mean, I don't think that's within the rules of. I don't think that's even logical or within whatever you would say in the course of judicial precedent. And I'll even bring up. I mentioned this in terms of the Hillary Clinton case. Well, these were confidential emails, right?
Right.
These were confidential emails. Well, I'm saying, nobody got the emails.
Right.
If nobody got the emails, whether they were confidential or not, and nobody got them, or again, her intent, you did it. Well, maybe, but you didn't think anybody else was going to get them. So writing the intent out of the law, as I guess they're doing with the Michael Morton Act, I don't know necessarily, as you're inferring, is not necessarily fair to the prosecutors either, because, if they didn't intend to do it, they didn't intend to do it. And as we were talking before the show too, there could be, how many I'm sure you've had cases, murder cases, etc., that you stamped, there were how many thousands of pages?
Yeah, no, we have. And we've had not just murder cases. I mean, even a theft case. We've had cases where if we printed everything out, we're going to go through probably 5 reams of paper just printing every single thing out because it was that much information that was just presented in that particular case. Or somebody who went to several hospitals because it was, let's say, an aggravated assault where they had serious bodily injury. Well, if they were in the hospital every day, that different reports are getting generated by the doctors, the nurses, everybody who treated this person, and it just keeps piling up, and that's just one part of that particular case. That doesn't deal with all of the information that would have been gathered by the statements that were taken or any of the other things that the investigators would have gathered and produced. So
you'd mentioned appeal, since we were talking about appeals, and you did. You actually told me before the show that you do your own appellate briefs. In other words, if the criminal defense loses and they file an appellate brief, they do an appeal, you file the response yourself?
Yes, I've handled all of the, since I took office, I've handled all of the appeals that have come out of the 79th Judicial District. Before, when I was there as an assistant DA, usually if you handled the trial, you also ended up handling the actual appeal. So I already had some experience dealing with appeals. If the DA handled a case, usually one of the assistants would get assigned to write
the
it up.
DA, and that was under Joe Frank Garza, correct?
Yes.
Okay, and under Joe Frank Garza, then you would, he wouldn't do the appeals, but now you're doing them as a DA, correct?
Yes.
When do you find times, to do a criminal appeal from the defense side, I'm guessing, it's hard to guess, but 50 hours. Yeah. Now, from the criminal defense side. Mm-hmm. Now, yours is probably quite a bit shorter. How long does it take you to write an appellate brief? 12 hours? 20?
Maybe about 20 or so. I mean, I will tell you, it's easier from the state side because
I've
done both sides.
Sure it is, because like you said, all the appeals of that, you probably have a checklist, I'm guessing. Mm-hmm. You probably have a checklist. That's not reversible error, error not, right? Yeah. You probably have a checklist.
Yeah, well, the thing
they
is,
made it real easy for you guys. I'm just teasing.
Not real easy, but the thing is, you've already filed your brief by the time that I'm going to respond to it, so you've already told me what you're complaining about.
Right.
So whereas
you address them.
Yeah, you had to actually go through and siphon through all the information that came out at trial. You're having to decide, this is my point of error on this one. I think here's another issue where the court did this so you had to identify everything. That I think takes a lot.
Yes, you have, and you just respond to those.
Right. Now, the research that has, that doesn't change, but I'm doing the research on your points that you've identified. You've done the research and you had to identify all of those points. And if you weren't on the trial, that means you started brand new, having to read the record. Where at least if you're on the trial, you kind of
the issues we're in. And that's complicated too, whether or not whether the criminal defense attorney should actually do the appeal, because again, he's not going to allege ineffective assistance, he or she's not going to allege ineffective assistance of counsel against themselves. But then on the other hand, if you went to hire an appellate attorney that didn't do the trial, I've got one right now that I have to look and I have to read the entire trial transcript because I wasn't there, and I have to make notes, and then it's a lot bigger job to do that appeal for the criminal defense attorney, as you state, if he didn't represent the accused. We mentioned Joe Frank Garza, and he left office in some degree of, I don't know if I want your opinion, but I don't know if it's ever been intelligently discussed. Here's from the Alice Echo News. I believe this is KIII off the internet. Former Jim Wells County District Attorney sentenced to serve county jail time. Mr. Joe Frank Garza was sentenced to 180 days in the Jim Wells County Jail as a condition of 10 years probation. and this had to do with the misuse of the forfeiture fund, which is basically the forfeiture fund is when, generally speaking, cars, I think it's usually cars, trucks, and money is forfeited by the state because drugs were being transported and or sold by the use of these, vehicles, etc. Right?
Right, right.
So, do you still have control of the forfeiture funds, or have they taken it away from you because the former DA was unfortunately, and he's a friendly acquaintance of mine, by the way, and I did like Joe Frank, so I felt badly for him that he was convicted of this, and of course, the underlying case I'm not that aware of.
Well, as a district attorney, I do have control over the funds. The way it works is the attorney representing the state, which is defined as the district attorney or criminal district attorney, has access to those funds if they are in fact forfeited. Those funds, if there's not a local agreement between the attorney representing the state and the local law enforcement agency that actually did the seizure, all of that money would go up to Austin. It'd go to the general fund, but there is a way to keep those funds local, and that's by having that interlocal agreement. I do have an interlocal agreement with every agency that's in Jim Wells and Brooks counties, in which case, let's just use an example of a money case. Let's say they were to stop $100,000 and they seized it and they believe that it falls under one of the criteria to have it forfeited. Eventually it gets forfeited. 25% of those funds would go into an asset forfeiture account that's controlled by the attorney representing the state. 75% will go to the agency that was involved in the seizure. Now, my understanding, when Joe Frank was involved, he had control over like the checks and stuff. We don't have control over the checks. If I want to spend any money out of that asset forfeiture account, one, I have to provide the Commissioner's Court with a budget, which I do every year, that basically breaks down what we're going to spend it on and what line items how much is going to go in each line item. And to actually get those line items paid out of, I do a purchase order. Purchase order goes to the auditor's office. Auditor's office then processes it by taking it to basically through Commissioner's Court, and it goes through all of those items, and then that particular expense will be paid for.
So when Joe Frank Garza, sorry about that, I think somebody's phone might be mine, but when Joe Frank Garza was the district attorney, there weren't all these safeguards in place.
That is correct. That is correct.
Sorry about that. How much money do you have in your forfeiture fund?
Well, what was budgeted for this year was about $450,000. And each year, the way I do it is, it used to happen where
when budgeted for this year, how much money is in the forfeiture fund? Is it for you don't know? Is there? Well, there must be a bank account sitting there. I guess that's what I don't.
Yeah, there is a bank account.
I'm not trying to, or approximately. I'm just curious.
Well, I'm going to tell you how we handle it.
Okay.
The way it used to be handled is somebody would write up a budget, and the budget was usually, I guess, a guess as to how much
money
we
you're
think is going to come. Yeah, I don't do it that way.
I don't know how they could do that.
Yeah, well, that was the problem. It wasn't a good way to prepare a budget. It really wasn't. I went and, when I worked for Joe Frank under his administration for about a little over 11 and a half years, when he went out of office, lost the election, I got hired in Clayburgh and Kennedy, and I got to work under a different DA, John Hubert. While I worked for him, he had a different approach, an approach that I liked and I adopted when I became DA in Jim Wells and Brooks, and that was he budgeted for, let's say, the next year what came in this year. In other words, money that comes in this year, I'm not touching it. We're not using it. We're not messing with it. If it gets forfeited, it gets put into an account. It's going to be held there. At the end of the year, I'll know how much is there, and then I'll prepare a budget based on what's actually in there. So if I budget $450,000, there is $450,000 in there. Now, some of those cases, it's hard to say, like, at this point, since we're early in this year, what is 2017 going to look like? I won't know that until I get closer to the end, because it pretty much depends on how active and how successful the interdiction officers are. The more successful they are, the more money comes in. And I can tell you, between Jim Wells and Brooks, compared to like Clayburgh and Kennedy. Clayburgh and Kennedy, when I was over there, they had a very successful interdiction unit, but because they had a couple of units, like with the Kingsville Specialized Narcotics Task Force, that they only survive based on how much
money
they get. So
if they get money.
Yeah, there's
so it was worthwhile for them to try to take all this money and vehicles. I'm just being
right. I know.
The mode, in other words, you wonder whether or not that might tempt them to try to seize vehicles and money that really shouldn't have been seized, merely because they could protect and pay for their own budgets.
Well, and that is the argument. I think that's the issue that has always come up, and I've heard the term, hey, policing for profit and things of that nature. And when you hear those terms, it's like, well, could it be something that could be taken advantage of? Well, you brought up Joe Frank and how, there's a way to take advantage of the system potentially when the money comes in, but is there potential that you could take advantage of the system even from the beginning part? There is, and I think that's why over the years more has been put into Chapter 59, which is the asset forfeiture section of the code, to try to protect the public and protect the individuals that are getting seizures. And it used to be that years ago you'd hear these things of, oh, they got them to sign over the money on the side of the road. Well, guess what? Because that became an issue somewhere in the state of Texas, they changed Chapter 59 to say you can't do that. And so little by little, as issues come up, legislature takes action to make sure, no, it can't happen, or it better not happen.
What's the biggest forfeiture you ever handled? In other words,
well, we had one that was probably the biggest one, was almost $5 million, but
wow,
the federal system ended up taking it over, but it should have stayed probably stateside. But they took it over. And
do you remember some years ago? I think you and I had a case against each other. I think there was about 350,000.
Yeah, it's probably about right.
Remember that? I
remember more or less figures. I don't remember how it.
And I think my defense was, one of my defenses was the warrant. I think it was a warrant issue or somehow they didn't have a warrant to search the trailer or something where the money was found.
And then whether there was actually would have been a nexus to the trailer or something.
Something.
Yeah, I think I
remember that, and I think we settled that. I don't remember, not for as much as I wanted. In other words, sometimes there is compromise and settlement in a forfeiture action, right?
Yes, and the code allows for that. That way,
so maybe you both take half the money or something.
Yeah, or depending on the facts of the case.
Right.
Sometimes you get issues. Like I can tell you, I've got one where the issue has really been the state not being able to comply with some of the discovery on the civil side. And the reason we weren't able to comply is because the canine that was used to do part of the search was out of one of the federal agencies.
And you couldn't get the
canine.
We
couldn't get the canine information. But hey, the defense is entitled to it. It's something that they can use for their defense, something they can use for preparing for trial. But those issues where on the state side, we have no control over it, but we filed the case.
I could say a lot. And the reason I don't say more is because some of I might want to use it at trial. And, but there are studies that do indicate that the dog does what the police officer wants him to do. He's reading the cues from the police officer rather than the smells of the vehicle. Have you ever heard that?
I've heard that, and and
that's
that might have been what the defense issues. Attorney was wanting to develop, but without that information, he can't try to develop it, and that ends up being an issue. That maybe we want to try to compromise and come up with a settlement on this case because of certain issues that are there.
Did you ever try one of these forfeiture cases? actually go to a jury trial, and the jury decided whether or not this money or car should be forfeited? It seems like most of them don't go to a jury trial because I'm thinking of the expense of a jury trial,
Yeah, I
a
think
civil jury trial.
I think because of the expense, and then a lot of times when we have had hearings or trials, it's generally the few times that it's gone to trial, it's been just a bench trial. And I think it's because on the criminal side, unless you waive a jury trial, you're going to get it. On the civil side, somebody had to request it. And I know from the state side, it's like, well, if we request it, there's going to be a fee. Where are we going to get the fee from? I don't have a line item that says that.
Oh,
and on the defense side, the defense might be thinking, well, you know what? I think my issues are more as a matter of law, and I think I'd have a better issue with the judge on this, or maybe just hell, time went by and I didn't know I needed to ask for it, because I've had that happen too. Where,
yeah, a lot of the criminal defense lawyers don't know civil law, and a lot of them get those cases, so they don't really know how to. I don't even know if a lot of them know how. They either don't know how or don't want to bother because it's a different kind of practice. They don't want to do the interrogatories or requests for productions or depositions, or right.
Right.
So, in a jury trial, that's probably more pertinent than if you just go before a judge. You also do other counties. You mentioned Brooks County, but sometimes I practice in these different counties, and sometimes I get confused. So Brooks County is actually where the one checkpoint is, the the Falfurrias checkpoint. Did you say?
Brooks County has a Falfurrias checkpoint on 281.
And that's a border checkpoint where if you drive down 281, you're stopped and you're usually asked, "Are you a United States citizen?"
Yes.
And you say yes, and they usually let you go. But there's usually a dog there, allegedly smelling to see if you have narcotics in the vehicle or any illegals. I don't think they could really smell for illegals, right? I don't think they could detect illegals. They could detect marijuana, but
yeah, I'm not sure exactly
so.
what I know different canines are trained for different things. Some are for, I guess, to be able to identify or alert to
I don't think I ever
people,
remember
but I'm not sure.
alert to people. I don't know about that. So,
because usually those ones, when it's dealing with a person, they end up being handled through immigration. So those cases never really came to us on the state
what
side.
cases at the border actually came to you then, if the illegal cases didn't come to you because they were prosecuted by the feds?
Usually the cases that we ended up getting were possession of marijuana cases. Back when I was an assistant, it was up to 140 pounds. I know.
And over 140 pounds, what would occur?
Well, it was over 140 pounds. The federal system was supposed to continue on, because once they were stopped by federal agents, it was a federal case. If they wanted the state to adopt it, we had to have an agreement. And back then, the agreement was the state would handle first-time offenders of less than 140 pounds or under. It later got moved up in some of the other checkpoints, because I had also worked in Clayburgh Kennedy, and they had a checkpoint in Sarita, and theirs I think was maybe at 250 pounds was the cutoff. But a lot of the state, before I took office, the prior administration had already stopped taking those type of cases, and really a big part of it was the expense. There used to be a fund that the federal government would reimburse the counties that were handling these cases for a portion of the expense. Well, once those monies came down, it pretty much left all of those expenses to be handled by the local jurisdiction, by the local county. And, every person who gets arrested ends up having to be sent to the jail. They'll get processed. If they can't make a bond, they're going to stay there. They need to get fed. If they're sick, they're going to have to be treated. If they can't afford an attorney later, one will get appointed to them. Well, all these expenses end up coming out of the general fund. And when you're dealing with a county like Brooks that has less than 8,000 people, that's a big strain.
They got some pretty big forfeiture money.
Well, but the forfeiture money, they would get some forfeiture money, but the big money cases were usually money cases out of Jim Wells County. So, Jim Wells County, the sheriff's department and we might have monies there, but in Brooks County, it was really the monies that was coming out of vehicles that were being auctioned off. But if a vehicle sells for $1,000, but when you add the housing of the person who got arrested, you add the amount that was spent on them, you add the for a court appointed attorney, you added all those things, that $1,000 didn't cover the expenses involved in actually processing and prosecuting that criminal case. Now, my understanding, and I don't agree with this, is what's happening right now is basically a catch and release, where somebody gets arrested or gets stopped for, let's say, having 40 pounds of marijuana at the checkpoint. The federal government isn't doing anything with them because it's too small of a case
45 pounds, okay.
for their resources.
Yes.
But then on the state side, it's like, well, if we take it, that means we have to adopt it, and we're going to have to spend the money. And we know we're probably not going to recoup enough funds out of any of the things that are attached to that person, whether it's an asset forfeiture case, or in some cases it's not an asset forfeiture case. Let's say they were on a bus. So there is no asset forfeiture that is going to offset processing that particular individual.
So right now, I mean, then there's real realities of the budgets of your office regarding prosecution.
Yeah, and it's not even really my office. I've told them, look, I've got a prosecutor who can handle those cases. Is what I can't do is tell a sheriff's department or a county, look, we're going to start accepting all of these cases. You figure out how to pay for it. If they have the funds to pay for it, I tell them, look, we will do those cases. I don't have an issue. As a matter of fact, I don't agree that they're not getting prosecuted. But then some of them had said, well, let's start off with the small cases. Let's take maybe up to 10 pounds. And I said, okay, well, we're going to prosecute a person who had 10 pounds. We're going to go ahead and hold them accountable. But the one that had 50 pounds, 100 pounds, we're not going to hold them accountable because the feds aren't doing it and we're not going to accept it. So, how's that fair that you had less? You had the person who got stopped didn't have as much, but we're going to throw the book at you. But the one who had even more, we're not going to throw the book at. So those are kind of questions that come in. Look, we either try to handle them all or we try to handle none, or maybe we go with the higher cases instead of the lower case. It's just those type of issues that when you're dealing with them, you end up saying, okay, well, we've got one district judge too. He comes and has court so many times a month. If all of a sudden we're taking all these cases, how many extra cases a month is that? Is that 50 extra cases? Does that mean that now he's got to, bring in all of the, more resources? And those are just things that, like I said, for my office, I can answer, we can handle those cases and we'd be willing to handle those cases. But for the rest of the county, I don't want to put the county in such an economic strain that they're having issues. Like when I first took office, they were in a point where they were not knowing how they were going to finish making payroll till the end of the year because they were so financially strapped. So I don't want to be the one that puts them in that position again.
Well, what about the legal changing subject, since we're talking about marijuana? And I don't know. I mean, you have a lot of judicial. You have a lot of discretion deciding how much time you would offer somebody on a plea bargain for possession of marijuana, correct?
Yes.
In other words, you could offer maybe somebody, even the second time, maybe 5 pounds for felony possession and delivery. You could offer them probation again as a plea bargain, correct?
Yes.
And this is kind of a general question. And it could be very, nuanced. So one day you wake up and the state of Washington has legalized marijuana. And Colorado has legalized marijuana. And marijuana is against the law in the state of Texas. And you're saying, well, so the defense attorney comes up to you and says, hey, man, you want to give my guy prison time for 5 pounds of marijuana, and it's for his personal use, and up there in Colorado, it's legal. What are you doing? Whatever. I might joke like that anyway. Mm-hmm. But I mean, how do you make your decisions regarding when there's a change in social policy in the United States regarding, especially that one's very confusing. it's illegal on a federal level. It's legal in two states, perhaps, and Washington, D.C., and it's legal for medical usage in other areas. I mean, do you ever consider that? Well, how serious is this crime now nationally, but it's still a crime in Texas? I mean, do those thoughts ever go through your mind?
They do, because I know this last legislative session, you did have some, because I went up, I was on one of the legislative committees to go and try to get some changes made on some of the laws. And while I was up there, they did have some discussion on one of the groups. I think it was on the Senate side, where there were some groups in there that were basically trying to get different laws passed or changed dealing with legalizing either marijuana or certain portions of the law to allow, and some did end up passing, but that discussion was already there, and because it's happening, it's something that as a prosecutor, yeah, we start thinking about it. Okay, well, what if this changes and this changes? What's that going to do with our system? What's that going to do with the guy that, let's say, they change the law and say, well, you know what, now under this amount is going to be a non-prosecutable offense. It's just going to be, if it's under 4 ounces or if it's under a pound, it's not even saying it's going to be against the law, but there's no punishment to it or whatever they decided. Okay, well, what about the guy that 2 months before you pass this is on probation for just that amount? How's that fair to that person that, had I just gotten caught 2 months later, I couldn't be prosecuted for it because they decided,
right. Retroactive laws, etc.
Yeah, so we start looking into those kind of things and seeing, well, how are we going to handle it? Now, the way we've generally taken it is, look, if it's still illegal here, we're going to go ahead and now, would it change what the punishment? Yeah, it's probably going to change what the punishment is offered, just because we got to go by community standards as well. Because I can say to you on a case, let's say we had a case together and I'm telling you, you know what, I'm offering your guy 5 years to do. And you end up saying, well, I don't think this judge and I don't think a jury would give my client 5 years. Right. I think this is a punishment type case. I think this is one where we just can't agree to on punishment. And guess what? We go to a jury. The jury ends up saying, you know what? I agree with the defense. This is a probation case. And they end up sentencing the person for probation. Well, you know what? I misread the community. I didn't, but now I'm going to use that case on the next time that I say, well, you know what? 5 years ago on this particular type of case, they used to be stricter in my jurisdiction. Now they're not so strict. Now they're not really seeing it as bad of a type of crime as they did 5 years ago. So now maybe I need to change my stance on what I would offer.
So you do try to read the community. Are you seeing many synthetic marijuana cases now?
Yes. Synthetic marijuana is probably one of the biggest thorns in our side right now when it comes to Jim Wells and Brooks. It's affecting a lot of people in our community. And the biggest problem we're having with it is, a lot of these people that are using it are thinking, oh, this is the legal stuff. And we've tried to get the information out to tell them, look, it is not legal.
Well,
and trying to show them, look, it's causing a lot of damage because
they think, but a lot of times they think it's legal because they were buying it in stores in Houston.
Exactly.
Right?
Yeah, and they were buying it in stores in Jim Wells County and in Brooks County too. I mean, they were being sold. You go into a store and they've got, here's all the cigars and cigarettes, and then right next to it, here's a package that, whatever they label it as, whether it's labeled as Kush or whatever the brand name happens to be. And so they could buy it there. So they're thinking, well, it can't be illegal because I bought it in a regular store out in the open.
I've heard 2 or 3 prosecutors tell me that they're for the legalization of marijuana because of the fact that synthetic marijuana is so harmful that they would rather see people doing actual marijuana than synthetic marijuana.
Yeah, well, I wouldn't go that far,
right?
But as far as those two, when you're dealing with marijuana and you're dealing with synthetic, yeah, synthetic is just so much more dangerous. I mean, because the even though it might be packaged the same way, you have no idea what chemicals are in there, and some of these chemicals are permanently changing the minds of the people that are using it. We had one case early on where it was a young person that the day before he was a regular, person. He thought, thinking process, regular. He ended up using that and basically got to the point where it didn't look like he was ever going to be competent to stand trial for his crimes.
Yeah.
And the main thing that the doctors tied it to was the use of that synthetic marijuana.
I don't know, where did they come up with that even word that it's synthetic marijuana? Because I'm not certain that, do they try to actually chemically, I think it's THC is the active component in marijuana. I don't know that they're actually imitating THC. They're just spraying chemicals on this stuff that is leafy, right?
Well, yes, but the chemicals that they're spraying on there are apparently chemicals that are supposed to mimic parts of what the marijuana actually does. The thing is, my understanding, the reason why it's so much more dangerous is there's no controls, whereas marijuana, there's only certain amount of receptors on there that can get connected to. I don't know. Yeah, it's complicated, but these chemicals are to the point where you just don't know what you're ingesting and what it's going to do to your system.
How is a DPS lab, because they were backed up for a while, and I don't think you could prove a chemical marijuana case unless you have a laboratory test, right?
That is correct, and they were backed up, and for a while they wouldn't even test the synthetics unless they got a letter from our office stating that we would in fact prosecute it, because there was just so much of it that was coming in that they just couldn't keep up with all of the different cases coming in from all of the different departments that their region covered.
So on a first-time synthetic marijuana case, if it's a minor amount, I would assume that's going to be a probation case, though. Is that right?
It probably would be. I mean, the thing is what we would really be looking for is not so much on the punishment, but on the rehabilitation. We need to get people that are using that off of it in whatever means we can, because to me that right now is probably one of the most dangerous, because we have other dangerous drugs too, but we've already learned how to deal with some of those. This is one that's still being developed on how do we handle it, how do we investigate it, how do we get people that are on that the help that they need. That's the one that's still developing. People that have been on heroin, people that have been on cocaine, people that have been on these other drugs, they've been around long enough where studies have been done where we have better answers for what we think we need to do for them.
Well, this has been District Attorney, 79th Judicial District, Carlos Omar Garcia, named after the movie star, Omar Sharif. He has an upcoming election, and I wanted to thank you for coming on, Mr. Garcia. I do appreciate it. Thank you.
Thank you.
Thank you. Good luck in the election.
Thank you very much.
I guess they say, I think it's another man. May the best man win, right?
Yes.
Thank you.